A few days ago, the United Nations Human Rights Office issued a statement condemning the fundamental discrimination, Citizenship Amendment Act. While welcoming the goal of protecting persecuted groups, the UN body called out against the exclusion of Muslims, including minority sects. The statement pointed out that the new law undermines the commitment to equality enshrined in India's constitution. The act also goes against India's obligation under the International Covenant on Civil and Political Rights and the Convention for Elimination of Racial, both of which prohibit discrimination based on racial, ethnic or religious grounds. The Suno India Show editor Padma Priya reached out to Pia Oberoi, Senior Advisor on Migration, UN Human Rights Office, to understand their concerns around the Citizenship Amendment Act.
Pia, your office recently issued a press release saying that the Citizenship Amendment Act, which was ratified by the Indian Parliament, was fundamentally discriminatory in nature. Could you please explain to our listeners why that is?
We expressed a concern that the act was fundamentally discriminatory because of the consequences that it could have on particular groups. We fully applaud and welcome the intention of the Indian government to establish a framework of protection for people that are being persecuted. And indeed, we've, as well as human rights mechanisms, have asked for a number of years that a robust national asylum system should be put into place to include people that are fleeing harm, persecution, conflict, human rights violations for all the recognized grounds. Our concern is that by only picking out not just certain countries, but within them only particular groups of religiously defined groups, there's a strong element of discrimination. We're concerned that, for instance, Muslim people of Muslim origin that are fleeing from these countries will not be considered to have suffered persecution and will be prevented from accessing the benefits of the regularization of the amnesty provisions of this act. Should there be really a concern to protect people that are fleeing persecution and violations, one could very easily imagine a national asylum system which puts in place non-discriminatory grounds of protection for all people that flee certain kinds of harm. And it's important that India does so to avoid these charges of discrimination.
Your press release further states also that the amended law appears to undermine the commitment to equality before law, one enshrined in the Indian Constitution, but also under different international covenants. Could you perhaps tell our listeners a bit more about these international covenants and which part is India party of and what has it not signed?
Certainly. International human rights law, right from the founding of the Universal Declaration of Human Rights in 1948, protects all people on the basis of their humanity, on the basis of their fundamental humanness. So we have a number of core international human rights instruments, such as the International Covenant on Civil and Political Rights, in fact, the International Covenant on Economic, Social and Cultural Rights, as well as the Convention for the Elimination of Racial Discrimination, which covers discrimination on religious grounds. Now, India is a party to all of these instruments, as well as having strong constitutional provisions to protect the fact that all people within its jurisdiction have certain fundamental rights, which cannot be legislated away, if you will. And this is important because it means that we can ensure that all people have a certain level of protection, not because they come into the country with a particular visa, not because they have a particular passport or because they profess a certain religion, but because on the basis of the common humanity that we all share, India is obliged to provide them protection. So this is the fundamental basis on which human rights protections and the fundamental principle of non-discrimination operate. In addition, we have protections within international human rights law to protect, on the one hand, refugees, such as the 1951 Refugee Convention and its 1967 protocol, as well as on the other protections for migrant workers and members of their families within the International Convention on Migrant Workers. Unfortunately, India has not ratified either of these two important conventions, and we would very much, call the Indian government to look seriously and consider seriously ratification. But even without that ratification, as I said, international human rights law, the core instruments that India has already ratified, call on the country to look seriously and with a non-discriminatory lens at all people on the move. We've seen that people move for different reasons, and often very individual reasons for protection as they move. We also don't insist, we don't believe that every country must open its doors to everybody that is on the move. International law fundamentally respects the principle of sovereignty. It is up to a government to decide who it wants to welcome into its country. But there's important caveats to that. One is that, for instance, you cannot render a person stateless in deciding to withdraw your citizenship from the person. So you have to investigate whether by withdrawing your citizenship, this person would face harm and human rights violations. And the second is international community over the last 2 or 3 years has realized that there needs to be a fundamental rethink about how people on the move are being governed. And this is not just related to India or to South Asia, but to really the whole world. We've seen big, complex movements of people in Europe, in the Americas, where the international community has decided to really think about what we need to do to cooperate better to provide protection to people. So on the one hand, we have had a process of development of a global compact on refugees, which India has been part of. And secondly, we've had the adoption in December 2018 of a global compact for safe, orderly and regular migration, again, which India endorsed. And taken together, these two frameworks really provide a roadmap for countries and for regions to come together to put in place protections for people on the move and to govern migration in a way that is fair for the communities into which they come, as well as for those people on the move themselves.